Good afternoon and welcome to today's presentation, Parameters to Determine Proper Use of Force. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the expert. All materials obtained from this presentation are merely for educational purposes and should not be used in a court of law sans the expert's consent, i.e. a business relationship where she or he is hired for your particular case. In today's webinar, Tim Dimoff will discuss use of force policy, reasons, factors for consideration, levels of resistance, rules, and less lethal alternatives. Tim Dimoff is the founder and president of SACS Consulting Investigative Services, Inc., which is considered one of the nation's leading authorities in high-risk workplace and human resource issues, security, vulnerability assessment, and crime. He is known as a speaker, trainer, investigator, and author, and has appeared on national radio and television shows and major newspapers. Tim is a nationally recognized expert on violent behavior and criminal investigation and has provided crime commentary and profiling analysis and has appeared on shows such as MSNBC, CNN, and Court TV. His expertise includes high-risk and security issues, human resource issues, corporate investigations, liability issues from hiring to firing, drugs and substance abuse, identity theft, law enforcement procedures, and victim justice. He has testified as an expert witness in many trials throughout his career. Attendees who require a passcode, the word for today is force. During the Q&A session, we ask that you enter this code into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log on to your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Tomorrow morning, we will send out an email with a link to the archived recording of the webinar. The slides can be downloaded from the resource list at the widget at the bottom of your screen. Thank you all for attending today, and Tim, the presentation is now turned over to you.
Well, thank you. And good afternoon to everybody, or good morning, wherever you're at. I appreciate it. Before I start, let me explain that 20 years in law enforcement, 20 years in law enforcement in a lot of levels, everything from SWAT to undercover to major cases. Also, during that career, I specialized, trained, and was retrained numerous times in different areas dealing with police procedures and had testified in numerous cases on use of force and trained officers on every form of use of force, from the smallest to the most deadly use of force firearm. Also, then 20 years of law enforcement, now 20 years on the private side. I want to make it clear that I have testified nationally in multiple states across the country at different times, and I have testified both for police departments and against police departments. I have testified for police officers and against police officer action. So I really think that it's important in this type of expert that you are willing to testify on either side, leaving your prejudices at home. And so therefore, with that basis, I will start. And there will be a Q&A, 2 opportunities for Q&A. So if you have questions, be ready to send those questions, and we'd be glad to address them. Also, every time I give a seminar here or webinar, people have additional questions. You will be provided my email and phone number. I will be more than glad to talk one-on-one with anybody about their questions or further details. Parameters to determine proper use of force. There's nothing more controversial, debated, discussed than the use of force by police officers, security people, etc. Okay, proper use of force, obviously, it's essential for the policing, and officers do derive their authority from the community. And that's important because you're seeing a lot of bigger movement of community oversight, independent committees, use of force review boards that are made up of community members, a cross-section of different members, ages, races, religion, backgrounds, And those authority committees, review committees, are making a significant impression and change as we move forward with this topic today and in the future. Okay, now unreasonable force really causes a lot of problems, as you can tell. It really affects the department, the legitimacy of the department. We get into human issues, ethical issues, respect for human life, etc., prejudices, and other things. But bottom line, the deadly force should be employed in only the most extreme circumstances. The training for police officers today is even more detailed and intense, that it really be only for the most extreme circumstances. Reason being, as we go through, we have alternatives. We have alternative tools that we can utilize. We have alternative actions that we can utilize. And when it comes down to the proper use of force, actually the circumstances along with your alternative tools and your alternative situations will dictate the outcome in most of these trials, if it goes to trial. Use of force policy. Across the board, no matter what state you're in, basically a use of force policy does apply to all commissioned officers. That is basically anyone sworn, badged, and armable who can make an arrest. Now, this is the cornerstone. It goes all the way back to 1989, Graham versus Connor. And this determination is still the backbone of any time there is a court dispute on use of force or consideration or debate. And in Graham versus Connor, it's on the screen, the court determined that an objective reasonableness standard should apply to a civilian's claim that law enforcement officials used excessive force in the course of making an arrest, investigatory stop, or other seizure of this person. Basically, it's basically saying anytime an officer restricts the movement or prevents the free movement of that person, and it can be for different reasons: arrest, investigatory stop, or seizure of that person. This use of force and these parameters do apply and are examined in a court in much detail. Hutson versus Macmillan, 1992. This deals with prisoners. So it's more like jails and prisons where this is important. This is where the use of excessive physical force against a prisoner may constitute cruel and unusual punishment, even though the inmate does not suffer serious injury. This is very important to remember. You don't have to have serious injury in order to file an excessive physical force. So that becomes very key in many of these cases of the past, and it'll become key in the future. You don't have to have a terrible ending in order to file a complaint of excessive force. So there is no mandatory that there be some damage or physical harm done to someone in an excessive way before you can apply or file a use of excessive force. Now, I'm going to show you in the next several slides. I'm not going to spend a lot of time on there. If there's a term here that you would want a little bit more clarity on, be prepared to ask for that term to be more qualified or explained as we go, and we can come back to it in the Q&A. But basically, we all know there's different levels of resistance, and we'll talk about that, and there's different approved weapons. I like to call them tools, and different things here that are going on. You'll see as I add them to there. Blocking has to do with a cruiser blocking other cars. Cuffing under power, sometimes people don't understand what that is. Basically, cuffing under power is when somebody has had the taser utilized on them, and while the officer has the taser on them, another officer comes up, rolls the person over if they're not on their stomach, and handcuffs them. So they're taking another action on the subject while the subject is being under control by another tool or weapon for the use. I think the other ones here on this slide we pretty much know. Electronic control devices, or ECDs, are commonly known as tasers. Force transitions is when you go to different levels of force. Once again, this Hutson Macmillan deals with prisoners. We'll go to the next one. Key terms to be defined. These are things that will be asked. Was there an immediate threat? What was the, what about intermediate force, meaning mid-level types of weapons? Who's the officers involved? What's going on there? And lateral vascular neck restraints, LVNRs. The one thing I want to point out, and you can see it in this picture, is that lateral vascular neck restraints is pressure on the side of the neck. And this picture clearly shows the officer applying pressure on the side of the neck. The reason for this is you can apply pressure on the side of the neck, and it is not a deadly force. It will cut off oxygen to the brain. It'll cause a person to pass out. If any type of vascular neck restraint is used on the front of the neck, that is absolutely deadly force, because it'll end up, in most cases, crushing the Adam's apple. The front of the throat is very weak, and in many cases, the person could die. So once again, all training on LVNR is to put pressure on the side of the neck, never on the front. That could be an issue in a videotape, or what an officer said they did, or the coroner's or doctor's report showing damage to the front, which is a totally different type of justification. They do not teach to ever do that. If it ever accidentally happens, it should be accidentally and no other reason. We have different levels of control, non-deadly force. We will go over some of these in later slides. Once again, we need to know what officers were involved, what officers witnessed the use of force, and be able to get statements. Usually in use of force incidences, it's not only important what the officer involved in the shooting is stating or putting in a report, but what the witness officers that were there also or came upon the scene, whatever, and all that. Ramming, basically ramming is not allowed except extreme circumstances. Ramming would be involving a cruiser against another vehicle, and we'll talk about reasonable force as we move along. So, what is the level of injury that happens? What's the reportable force that's used? Now with body cams, the question is, all the circumstances from when the officer first arrives on the scene, what is seen, what is heard, what is said, what is the conversation between the officer and the subject, what is the officer doing, what kind of instructions or commands, what is the action of the subject, what is the action of the officer, and obviously, does it match to the video of the body cam. Body cams have been significant in reducing use of force incidences by police and reducing the number of lawsuits against police for excessive use of force. It's a real balance for everybody involved in situations. So different things happen in different types of circumstances. And we get to the use of force reasons. Well, obviously, you can use force to protect yourself. The officer is protecting himself. He can use force to protect others who might be in danger of being killed or serious bodily harm or low-level harm, and then proportionally the amount of force used is proportional to the situation, the environment, and the series of events. Obviously, officers are allowed to effect lawful detentions. If there's any kind of resistance, they have the right to escalate to get detentions or arrests or searches, and sometimes those, even they're low level, may escalate. But if the subject escalates the resistance, the officer is justified in escalating his techniques to get back in control, to protect himself and to protect others. Now, requirements. Obviously, if a police officer is in uniform, they're identifying themselves just by their presence. But many times we have officers that are working undercover, or they're plain clothes, or they're a detective. Okay? So there is a duty to identify yourself as an officer, especially, obviously, if you're not in uniform. Now, the second piece of this is the more difficult, or the more emphasis should be put on this as we train officers. They must make it clear what their intention is. Is it to question someone? Is it to detain them? Is it to arrest them? Is it to search the subject? You, as an officer, must make it clear what your intent is. Otherwise, a person can walk away from you and not engage in conversation. We've had incidences that I've testified on where the officer just approached somebody and the person turned around and started walking away, and it escalated very quickly because the officer interpreted that action by the subject as resistance and escalation of resistance by walking away, and it came down to the clarity issue in this case, where the officer was asked, what did you say to the subject? And in this one case, the officer never said anything to the subject, such as, I want to talk to you, I need to talk to you, we're doing this or that, and the subject had no reason to believe that he had to stay there, which in fact the court proved that he didn't, and the officer's use of force on that subject was found to be wrong. And it all came down to the clarity. So clarity becomes very important, and many times it's a piece of the use of force that really needs to be examined, and you need to prove that it exists if you're an officer, unless it's obvious where someone has a weapon pointed at you or something. I don't think we have to have too much clarity there. But a lot of the lower middle levels of use of force, clarity many times is not utilized and can cause escalation or problems or misinterpretation by both parties involved. Now, you have to objectively determine force, reasonable force, and playing the backseat quarterback is not exactly the way the courts look at this, but we look at it from what would a reasonable officer on the scene, do in that situation, rather than a 20/20 vision hindsight. So it's not that reasonable force objectivity is determined by sitting at a table having a cup of coffee and having all the time in the world to figure things out. It's more of the reasonable. What would you do if these circumstances happened to you at that pace, at that time, with all those environmental actions, with all that interaction with the subject or subjects. So reasonable determination at the scene, not hindsight. And, why is that? It's obvious. Officers are making split-second judgment calls. And some of the stuff recently in the last couple of years where people think, well, that officer should have reacted this way or that way. And a lot of police departments, the National Institute of Justice, has taken people from different facets of the community. It can be preachers, it can be an office manager, it can be a person that works in a restaurant. And they've put them through the live video scenarios of what police officers go through to see what their reaction would be compared to what they think the officer should do. And we're seeing remarkable results in these tests and study that show that the common person put in that situation many times reacts different than they think they would, but it gives them a feel and respect for the officer having to make a split-second judgment. Once again, you can get tense, uncertain, rapidly evolving circumstances coming up, and those can change everything very quickly. And also our judgment of whether the force was reasonable or not. Now, different factors for consideration. Obviously, the severity of the crime. There's a big difference between someone who committed an armed robbery and is running out of a bank or a store with a gun hanging down versus someone that just stole a candy bar at a grocery store and they're calling in a description and you're pulling up and you see the person, they see you and they run and the officer chases them. Big difference between those two. So you really got to look at the severity of the crime as a major factor. Does the subject pose an immediate threat to the officer or others? Obviously, if they have a weapon in their hand, but what type of weapon? A gun is different than a knife. A knife is different than a crowbar. A crowbar is different than their fist. So, type of weapon, immediate threat, severity of crime, these are things that we continue that have to be digested very quickly by officers or others on the determination of use of force. And then once you confront the individual, are they actively resisting or are they passively resisting? They can passively resist by maybe saying, I'm not going with the officer, and they just sit on the ground, but they don't fight. They're passively resisting. We would handle them differently than someone that says, I'm not going with the officer, and starts kicking and punching and fighting or biting or spitting, etc. Other types of things that can happen is influence of drugs and alcohol. Also, mental issues can happen. Is this person on alcohol or drugs? Are they out of control? Do they have some types of mental issues going on? There's a movement to train more officers on all shifts, on all police departments, to deal with mental crisis situations where they either know the person from previous calls and histories at this location has some mental issues, or the person exemplifies some mental issues, where we're training specialized police officers to communicate and deal with those individuals, because it's a whole different set of tools in communication and trying to help them to basically diffuse or decompress. Once again, time available for an officer. If an officer pulls someone off to the side of the road, the officer's just getting out of their car and the person opens the door real quickly, jumps out and has a gun in their hand, that's a different type of time availability than maybe others. And very important here on the second bullet, availability of officers to de-escalate the situation. There's a new movement just in this past year for more thorough de-escalation techniques and training for police officers. What we're finding out is basically since police officers have existed, they've been trained to take control of the situation. They've been trained as a person doesn't allow control to increase their efforts to take control. And what we're teaching now, what you're seeing across the country is it's okay, it's smart, it's another tool to de-escalate the situation. So you confront an irate person and they start threatening the officer. It might be better for that officer to take a few steps back and explain that they're not there to cause problems, to arrest, to, harm them, to give them time to de-escalate or defuse. So we're looking at those. And as that becomes more popular or more pushed through departments of training, we're going to see the question of did you or could you have de-escalated your situation? And a lot of that is going to be physical de-escalation and verbal de-escalation. But that doesn't excuse someone who has a deadly weapon and you come on the scene, the officer, will still need to have control of that. But there are a lot of exceptions to that. And even sometimes in a de-escalation, it can be someone with a weapon. We do this all the time with barricaded subjects. They control the area. They make communication connections with them, who's barricaded or who's taken a hostage, and they start to negotiate, or they start to de-escalate or diffuse that individual. So this is not something totally new, but I think you're going to see more of a one-on-one de-escalation effort, and I suspect that then will turn into another question on the determination of the use of force and was it proper. Once again, proximity and access to weapons. Environmental factors are very important. There's all sorts of environmental factors that can happen. Are you outside, inside? What's the weather? What's the ground? Who else is around? What's the lighting? You can go on forever. Environmental factors are very important. Confronting an irate individual in a very low lighting is different than in lots of lighting. Lots of lighting, the officer has a true sense of what they're dealing with. In the dark, they may not have a true sense. That can escalate the need for use of force. Our arrested subjects, misunderstanding, we've already talked about this, but just to touch base, we're seeing people misunderstand, especially where we have language barriers. They can't communicate with the officer. They don't speak English or the language. We're seeing medical conditions vastly affecting some of these situations. That's why there's a movement of training officers to deal with the mental. It's listed secondly here. The mental situation for a lot of confrontations has increased over the last 10 years or so because people with mental challenges many of them used to be contained in facilities, and now in the movement in the last 10 so years, there's a movement to integrate the people with mental challenges into society. They're integrated and they are encountering stressful situations, and under stress, people with mental situations or challenges will react in a more aggressive manner, protective manner, panicky manner, and that can be misinterpreted by an officer, or that can escalate. So these things here. A medical condition obviously can affect it, and that includes drugs. Legal drugs that they're on, prescription, and illegal. And of course, mental challenges, and then physical, okay? Certain physical actions can cause a misunderstanding or can be interpreted wrongly by both police and subject. Once again, we had an incident where someone was hearing impaired. The officer didn't know it, thought the individual was ignoring him, and the hearing impaired person got into an altercation with the police officer. It should have never happened, but the officer didn't know the subject was hearing impaired, and that turned into an ugly court battle. We talked about language barriers, drug interaction, and emotional. We have people that are emotional. We have a lot of people that are on different types of drugs for emotional and unstable emotional levels, mental state, and that can escalate things out of hand too. We're going to go to Q&A here for a little bit if you have a question, and I'd be glad to address those questions at this time.
Thank you. We are now entering the Q&A session. Please remember that if you are applying for CLE credit, you must attend for the full 60 minutes of the presentation. Please enter the CLE passcode, which is FORCE, during this time. You may also enter any questions that you have for Mr. Dimoff. First question that we have is, what is the accountability of an off-duty police officer who effectuates an arrest and uses excessive force that prevents a third party from assaulting the victim?
Well, a couple things there. Off-duty officers, and we have a couple things. Number one, sometimes we have an off-duty officer that's working another job, a secondary employment, as security / quasi-police. In those situations, they're hired to do security performance. And we also have, I think what the question is pointing to is somebody that's an off-duty officer and sees a third party being attacked. And the debate, which has never really been 100% clear, two questions. Number one, does that officer have the right to protect that third party and to act according to his sworn police oath that he took? First thing is, any officer off-duty sees anything going on that could result in any level of harm or serious harm to another person has basically the right to intervene to stop that action. Okay? They have a right, and in some places people think that they have a duty, and that can be debated also. But basically, they do have the right to act to protect others when they are off duty. So they definitely have that. And in many states when that happens, automatically their police powers are there. Their protection that goes along with their police powers to act is also automatically part of that response by that officer. So basically, in most states, departments in different states sometimes will have guidelines that say you cannot get involved unless it's something of deadly harm or deadly serious. And you will have a few departments that will actually have stipulations like that. But for the most part, most states, most departments, the power kicks in and the police officer is protected to take action. Next question.
The next question is reasonable force. Reasonable to a juror or to the officer at the time?
Reasonable, did you say reasonable to the jury?
Correct.
Well, the jury is making the determination of whether the officer acted in a reasonable fashion. So the jury is supposed to put themselves in the officer's shoes, take into consideration the environment, the action of the officer, the action of the subject, and put themselves in the officer's shoes and say, was this reasonable under the circumstances of what happened? And it's important that they say, was it reasonable not only with what happened, but with the timetable, how fast it happened or how slow it happened, and how much time that officer had to think and react. The jury is not supposed to sit back and put the whole thing under slow motion and be hindsight of determining that it was or wasn't proper. So as much as possible, the jury is supposed to be a mirror image of the actions that took place between the officer and the subject, and do they think it was reasonable with all factors in consideration? Next question.
What's the difference between someone being detained as opposed to arrested?
Yeah, that's a great question. A lot of times people say, if I'm detained, do I have to stay there? And is detainment an actual arrest? And there's a lot of debate on this. I had a case recently that I was testifying on where an officer actually asked a person to stay at a location while they were in the middle of conducting a investigation which was an alleged rape. And detainment is not an arrest. Can an officer ask someone to stay at a location or stay with them for a few minutes or whatever, 5, 10, 15 minutes, whatever, because they're in the middle of an investigation or they're bringing a witness to the scene to take a look at the subject? Detainment is not an arrest, but an officer can ask someone reasonably to not go anywhere, stay here, etc., as long as it's reasonable. If that officer asks that person to be detained for 2 hours at a location, that's excessive. So, once again, the factors come into play on what's the circumstances. We just had a rape. We just had an arrest. We're bringing a witness over. Those are all feasible and very common things to request by an officer. But once again, that officer's request cannot be excessive. If it would be excessive, then it would be most likely found to be an improper arrest because it was so long and it was so restricted. And once again, the citizen would have a right to object to that. Other things can happen. If the officer is detaining someone, they can ask them reasonably for 5, 10 minutes or whatever. If not, then they can ask, where do you live, where do you work, and they can continue the investigation later. But most of the detainment usually surrounds, the debate on it surrounds the amount of time and circumstances of that detainment. Any other questions?
Yes. From your prior answer on reasonable force, reasonableness is a subjective, not objective standard?
Repeat that question again, please.
From your prior answer on reasonable force, reasonableness is a subjective, not objective standard?
Well, great question. Often debated. I personally try to be almost both in a weird way, but I believe reasonable force, is subjective in a lot of cases. Once again, it's really capturing the circumstances of the event. And that's why it becomes so difficult, because all the factors have to be considered, and then all the responses, which we're going to get into here in the second half, all the responses have to be considered, and you have to combine both what happened, circumstances, environment, and then the exchange between the people in question, and you have to try and do it in a very neutral way, so that you can be very neutral in your decision, and you don't let other things affect you that should not be part of affecting your decision. In many cases, we're all human. Juries are human. That is why it's so important to really dissect and pull out the different aspects of each case that caused what to happen, and determine whether that force should have, could have, and was allowed to escalate, or should have decreased and de-escalated.
Thank you for answering those questions. You can continue on with your presentation.
Thank you. Okay. Levels of resistance. We're going to have a chart here, which when you get the copies of this, you'll see it. But levels go from low level to intermediate to strong levels of resistance. As you can see here, you can be all the way from compliant to passive to active to very aggressive to aggravated with a weapon or whatever. These types of levels escalate up and down. The general rule is, as the subject increases his resistance, the officer also can increase their use of force or their level of use of force. Once again, we're back to the force must be reasonable in order to take police action, and it must be proportional to the circumstances and the level of resistance encountered. So, once again, what are the circumstances? What happened? And did the officer act accordingly? Someone spits on you does not give you the opportunity nor the permission that you can use a firearm, is a great example. So it's got to be reasonable and proportional. Low level, we'll just go through some of these kind of quickly, but, low level is everything just from officer presence, empty hand, verbal, baton, blocking, pinching. Those are car maneuvers. So those are low levels of force. Intermediate, you start to get into using the tools, and most people would look at this level being the baton, lateral vascular neck restraint, pepper spray, electronic devices, the shotgun with the blunt bullets in it, canines to take you down. Of course, pit is using car maneuvers. Now, this immediate force is usually the area that's discussed a lot or the most when we're looking at levels of force, because the question comes up, could you have used an alternative level of force? Usually they're referring to the immediate or mid-range force that's listed on this slide. Lots of officers will be asked, well, you were there, why didn't you use your OC spray? Or why didn't you taser the subject? So this slide's very important because that's where they focus. Deadly force, you start striking anywhere above the neck with a baton, you have some serious explaining to do, and generally they do not recommend nor train to hit above the neck. Obviously, pressure points throughout the body and arms and legs and different things, are good techniques. Deadly force, obviously, if you're hitting at a high rate of speed, a pit maneuver, ramming at higher speeds, obviously firearm use becomes huge, and all firearm use is deadly force. Once again, we've already reviewed this, but protect yourself or protect others, which is believed to be imminent threat or death or serious bodily injury. Remember, no one's usually debates, that you can use deadly force for imminent threat of death to you or someone else. Sometimes, though, serious use of deadly force where the officer believes that serious bodily injury could have taken place, that can get into a very deep legal battle in court. Now, escape of a fleeing felon who believes that would commit a violent, felonious crime. This one is been debated more and more in the last several years. And anybody fleeing from anything, many times now, they are not suggesting to engage. And the exception is a fleeing felon. And in a lot of cases, a good example of a fleeing felon would be a prisoner escapes from a prison. He kills a prison guard, escapes with the prison guard's keys or cars, keys to the prison guard's car. The fleeing felon has killed a guard, is now on the run. An officer has an ability to see that person and to prevent their escape. They use deadly force. That's more justifiable, but we have to be very careful about fleeing felons, and it really has to be a serious offense, or otherwise they really recommend and train today not to use deadly force. So here it is, an imminent threat to human life. If feasible, try to give some type of warning, verbal, and then if action is taken, it's more justifiable. What they want to see in the fleeing is the fact that you're identifying yourself and you're telling them to stop, or action will be taken, and they still refuse to stop or comply. Once again, Tennessee and Garner deals with fleeing suspect. The officer has probable cause to believe that the suspect poses a significant threat or death or serious physical injury to the officers or others if they don't attempt to stop them. So once again, the Tennessee Gardner clearly states, you really have to have a strong understanding that this person could cause serious harm or death to someone else. We had a case where an escaped prisoner did escape, was confronted by an officer, and on the other side, the officer decided not to use deadly force to prevent the person from escaping further. They were chasing him in a neighborhood. The officer had the ability to actually use deadly force and chose not to. That escaped prisoner ran through the neighborhood, and they lost him in the neighborhood. And later on, just a half a block away, they did find him. He broke into a house and he killed 2 occupants of the house. So this was a good example of, where it shows that if you do allow that person who is a felon or who could cause serious or death harm, could potentially kill or harm someone seriously. So it happens both ways, and that's why we need to have a clear understanding of who that person is and what their capabilities are. This is the one with prisoners under Hutson, Macmillan, which we talked about earlier. Once again, excessive force is not justifiable, and it doesn't matter the level of injury to the prisoner. So we got lots of elements on deadly force. And once again, these are the things that the jury must look at and that the officer must prove that they took into consideration and affected their decision. And it's, once again, the ability, of the person. How big are they? What kind of weapons do they have? Skill, environment. Where's their opportunity? Are they 4 feet away from hurting somebody and they have a baseball bat, or are they 40 feet away? An officer confronts an individual who's standing 20 feet away with a knife and tells him to drop the knife. It's going to be pretty hard to justify shooting him if no one else is around him. The person is standing still, is arguing, but is not approaching anybody, including the officer. Now, if that person all of a sudden takes off and runs right towards the officer, now that changes the circumstances. So, the imminent jeopardy, the preclusion. So, once again, under the preclusion, do you see where it says do you have alternatives? Alternatives are that intermediate that we talked about, use of force, other tools or weapons that the officer possesses. This slide here, when you get a copy of the PowerPoint, will really help you understand the levels. I tried to clearly show that each one of these levels. Now, when you look at this, the rule of thumb is the officer can use any force that is equal to or one above the force that's being used against them. In this chart, you can really see and say, okay, where is the subject's use of force, and correspond it to the officer's equal use of force or one above to control the subject. So when you get your PowerPoint, this one here is one of the more beneficial slides that I think will come into play very much so. We use this slide here a lot in court to show a visual to the jury, and it many times is very helpful. Use of force continuum is the gold standard, and that determines whether the force was proper and justified. It's the chart, is what you just seen, is the use of force continuum. The officer moves from one level to another when necessary. Also in that chart, if the subject de-escalates their use of force, remember the officer must de-escalate what they're doing. If they go from a physical aggressive fighter and all of a sudden just sit down on the ground and say, I'm not going nowhere, that officer cannot escalate and should not escalate their use of force. Question comes up, bullet number 4 there. Can an officer skip a level of force? Yes. Let's say you're talking to someone who's sitting on a sidewalk who doesn't want to leave. You're on a low level of the continuum because you're just verbalizing in your presence and you're talking to them. What happens if they reach in their pocket and pull out a gun? All of a sudden, you just skipped several levels because the officer may pull their gun out in retaliation because that person is sitting a foot away from them. That person not only pulls a gun out, but points it at the officer. There may be other indicators. So, yes, you can go up and down, you can skip. But remember, officer can use equal level force or one above is the standard that is utilized across the country. You need to justify why you skipped, and by justifying what were the additional circumstances that caused it. De-escalation, we talked about that. They do have the ability to impact the direction and outcome of the situation. And This is based on their decision-making skills. Once again, we're going to see more de-escalation techniques. And the other thing is, I believe we're going to see more debate in court with the question, all right, subject did this. Why did you not use an alternative mid-range tool or weapon? Secondly, why did you not de-escalate? Just like in this picture here with this officer standing near someone sitting on a curb. If this person starts to get agitated, that officer physically moving backwards a couple steps could de-escalate that person's aggressiveness or escalation, because you're sending a signal to them that you really don't want to engage them unless you have to. So de-escalation, mark my word, we're going to see a lot more discussion on this and debate. Duty to intervene. One of the other things that's really escalated in the court cases is, what about what we call the observing officer? There's two officers or one officer wrestling with somebody, and there's an officer or two standing on the sides there watching what this officer does. Does that observing officer agree with the amount of force that has been utilized by the officer as reasonable? Example, I just finished a case about 3 months ago. A prisoner was coming in. The prisoner was handcuffed. One officer had his left arm. 3 other officers were standing in their room as the prisoner was escorted in to the jail center. The prisoner jerked or pulled away. The officer grabbed his arm tighter and threw him into the wall. Now, that officer felt that he was using the wall as a message or a control technique. People would debate how hard you threw him into the wall. Did he get injured? This and that. Other people would say, why throw him into the wall? Why not just grab him and press him into the wall, press him up against the wall? Well, in this case, one of the observing officers was asked in court, and he testified that he felt it was not reasonable and actually was not necessary. And they asked him if he thought the officer didn't throw him into the wall, but pulled him into the wall and pressed him against the wall, if that would have been reasonable. And the other officer, who was the observing officer, testified, yes, that would have been acceptable to him. So you can see where this can go and get complicated with other officers that are in the area. Once again, you're only going to use department-approved weapons and training and techniques, and you do need to know policies, training, and all the training data for each officers in each tool they have to make sure they have training on each of the tools that they have, and they're not using something they've never been trained on. Less than lethal alternatives, they're there, they're very effective. We have many of them. I think the popular ones are the pepper spray, batons and tasers, bullets and shotguns that are not deadly bullets, they're more impact bullets, using them in riots and different things. So we've had some pretty creative tools to incapacitate and to help with resistance. Less than lethal, obviously, we're going to use them where they're needed. We have to be careful. All weapons we need to be careful about. Injury to innocent bystanders. There's always going to be an investigation or report on all use of force, no matter what level. We need to have a general report. We need statements from officers. We need to determine justification. And we need to correct any identifiable training deficiencies. Sometimes we have use of force. It isn't serious use of force or deadly force, but we see that things got out of hand and the officer didn't utilize some of the other tools they had. Sometimes we find out they're not confident with those tools, and the department needs to do some more upgrade training on those. And once again, anytime force is used, there needs to be a complete use of force report made, and it's going to become crucial in the courts. We have a few minutes here if we want to take a couple quick questions.
Please enter the CLE passcode during this time. The CLE passcode is force. You may also enter any more questions that you have for Mr. Dimoff. The first question that we have, if a suspect is fleeing and there is no apparent threat that the suspect will harm others, is shooting at the suspect's legs considered excessive force?
If the suspect is fleeing and there's no real thoughts or evidence or history, belief by the officer that the person can harm someone, shooting at their legs, in my opinion, is not permissible, should not happen. The reason is simple. What happens if you shoot at his legs and the bullet goes a little higher and hits a femoral artery in their thigh and he bleeds to death in about a minute and a half and dies? Your intention was to stop or hinder him, not to kill him. That is why police officers are never trained to shoot at an arm or a leg and just temporarily or low level prevent them from escaping or prevent them from harming. Anytime a firearm is fired, bottom line is it has to be justifiable use of force, deadly use of force. It has to be justifiable for deadly. It cannot be justifiable for any other reason. Next question.
Are there any standards for bar bouncers?
Yeah. I testify quite a bit, ironically, on bar bouncers, security in bars, restaurants, events. The bottom line is, in most of these type of circumstances, is just like a police officer. You want to find out if they have any training. They should have some level of training. You want to also find out if there's any type of policy with the bar or restaurant or event. There should be some kind of written policy or guidelines that stipulate what they want them to do, what their responsibility is. But private security does not have the same latitude as a police officer. Anybody, whether they're police, security, or a person walking down the street, has a right to protect themselves. And if they feel seriously bodily injury is attempted on them or deadly injury, they have the right to protect themselves all the way up to deadly force. But basically, bars and restaurants and bouncers are held to a little bit different standard, and you need to have some sort of organizational training and guidelines for them. Next question.
Last question. Does a significant threat mean at that moment?
Well, good question. Significant threat, in most cases, does mean at that time, because let's say you had a person murder somebody down the street at a shopping center. They got a description in a car. Police officers are in the area, see the car. They pull the car over, and the subject gets out of the car. The officers confront him, and then the subject starts fighting the officers. There's no weapon seen. The officers have knowledge that he killed somebody just 10 minutes ago, murdered him. That doesn't justify the officers using deadly force at that time, because that person is not showing any intention of deadly force to the officers. Now, change it up a little bit. The subject starts choking an officer, trying to choke him and kill him, that escalates the use of force to equal or one above, and then the deadly force by another officer or the same officer would be justifiable. But the bottom line on that question is yes. You can't base it on something that happened 5 minutes, 10 minutes, an hour ago, 2 days ago. You have to base it on the imminent confrontation situation that's presently happening. Thank you.
Thank you, Tim. Please remember that if you are applying for CLE credit, you must attend for the full 60 minutes of the presentation. You are also required to complete the survey at the end of the program. I want to take this opportunity to thank everyone for attending, and most especially Timothy Dimoff for his time and effort in creating this presentation. The TASA Group, in addition to being your best source for testifying and consulting experts for the past 60 years, TASA also offers e-discovery and forensic solutions, free interactive webinars, day-in-the-life videos and research reports on expert witnesses such as Challenge History Report 2.0, Professional Sanction Search, and Expert Profile 360. If you would like to speak with Tim or you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA 1-800-523-2319. One of my colleagues will be following up with you regarding your feedback on today's presentation. This concludes our program for today. Good afternoon and welcome to today's presentation, Parameters to Determine Proper Use of Force. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the expert. All materials obtained from this presentation are merely for educational purposes and should not be used in a court of law sans the expert's consent, i.e. a business relationship where she or he is hired for your particular case. In today's webinar, Tim Dimoff will discuss use of force policy, reasons, factors for consideration, level